Scott, and I am an attorney and a passionate special needs advocate. Since I was a child, I had a passion for juvenile rights and advocating for children. I became an attorney after graduating Emory Law in 2020. When I was at Emory, I focused my studies on children's advocacy. I took classes on child welfare and education law, and I worked representing foster children in court. After I graduated, I had my first child who was born with many special needs. I immediately had to use the skills I learned as an attorney and a litigator and my passion for children's rights to fight for him. I understand firsthand the unique challenges and triumphs that come with navigating disabilities, so it's my mission to support and empower families who might have a special needs child, navigate the school system, and financial resources available. We believe that there's no more powerful advocate than a parent armed with information and options. Because we believe that, we offer free trainings every month. Some of our upcoming topics include decoding progress reports and IEP data, parental rights and procedural safeguards, common mistakes parents make in their IEP or 504 journey, what to do when your IEP or 504 isn't working, along with financial workshops. So make sure you like and follow us on both Facebook and Instagram, and you'll get the workshop information every month. Today in our boot camp, we're going to start by covering IEP basics, including what an IEP is, who qualifies, and the difference between an IEP and a 504 plan. Then we're going to discuss who are the key players and key roles in the IEP process. We will discuss the types of meetings and the meeting process. And then we're going to do a deep dive into the components of an IEP, including present levels, goals, accommodations, services, and progress monitoring. And finally, we're going to look at a real-world IEP in order to see what we've learned today in action. And then we'll get to questions. Before we go into the mechanics, let's anchor on this. An IEP is a child's roadmap for learning. It's also a legal commitment from the school and the way we hold the school accountable. IEP stands for Individualized Education Program. It's a written plan created by a team for a student ages 3 to 21 in public schools. This includes charter schools. It exists under federal law called IDEA, which stands for Individuals with Disabilities Education Act. Think of it both as a program and a contract because it's going to spell out exactly what specialized instruction and services, as well as supports, the school will provide so the student can make progress. An IEP is how we deliver FAPE, a free, appropriate public education. That means services are provided at no cost, they meet state standards, and the services match what's written in your child's IEP. It also protects your child's right to the LRE, or least restrictive environment. Students should learn with non-disabled peers to the maximum extent appropriate, with supports added before moving them to more restrictive settings. IEPs are developed in team meetings. That includes parents, general and special education teachers, district representatives, evaluators, and others you might invite. We'll go into this in detail later. Parents are equal team members. You can bring an advocate, an attorney, or a support person. Initial evaluations require parent consent. After eligibility, the plan is reviewed at least annually, and there's a reevaluation that needs to occur at least every 3 years. If the school proposes or refuses a change, you should receive a prior written notice, or PWN. This is a very official document that will explain what and why what is being refused, why it's being refused, or what change is being made and why, and they will explain any data that they use to come to that decision. An IEP is not a placement label. Remember that placement follows the child's needs and supports. It's not a menu based on budget or convenience. Services are based on need, not budget. It's not just accommodations. It's instruction, plus services, plus supports working together. And finally, it's not a suggestion. Following an IEP is federal law. Now that we know what an IEP is, the next big question is who actually qualifies for one. Not every student struggling in school is automatically eligible. The law sets specific criteria. To qualify, a student has to meet a two-part test under IDEA. Number one, the child must have a disability that falls under one of IDEA's 13 categories, which we will cover these on the next slide. That disability must adversely impact the child's ability to learn in the general education setting and require specially designed instruction. Both parts have to be met. A child might have a diagnosis, but if they don't need specially designed instruction, they may not qualify for an IEP. So a medical diagnosis can help, but the school team, not a doctor, decides eligibility under IDEA. You don't have to wait until a child is failing to get an IEP. Schools have a child find duty. Under this child find duty, they have to evaluate when there's reason to suspect a disability. So it's not just on you, the parent, to realize your child needs to be evaluated. Let's talk about what adversely affects education means. This doesn't just mean grades. It can include difficulty accessing the curriculum, struggles with behavior or social skills, communication or language barriers, health-related issues that interfere with attendance or stamina, or functional needs like organization, self-care, or mobility. So even if a child has passing grades or even excelling grades, and if they're still struggling significantly in other areas, they might still qualify for an IEP. Evaluations and data drive eligibility. Eligibility is decided through a comprehensive evaluation conducted by the school. Parents must give consent for this. The evaluation looks at academics, cognitive skills, communication, behavior, social and emotional functioning, and physical or medical needs. The assessment should look at all areas of suspected disability. So if they have a reason to suspect speech, they need to look into that. Parents can provide private evaluations, and the school must consider them. As an advocate, a lot of times we are very successful in getting private evaluations put into the IEP in some way or another. We'll look at this a little bit later when we do our real world IEP review. I want to talk a little bit about an IEP versus diagnosis. As I mentioned before, an important point is a medical diagnosis doesn't equal automatic eligibility. So just because a child may be diagnosed with ADHD or autism, if they're doing fine in school and they don't need any specialized instruction and everything's great, they might not qualify for an IEP. They might qualify instead for an 504 if they just need some accommodations, and we'll look at that a little bit later as well. On the flip side, a child doesn't need a medical diagnosis if the evaluation shows an educational disability that requires special education. So we might have a kid who we very highly suspect has autism, but they've never been diagnosed, but they go through the eligibility process and they're determined eligible because they have significant needs. If they are determined eligible through the education process, they don't need to get that autism diagnosis. They won't necessarily qualify under autism, but there's other ways for them to qualify. Let's go over a few examples to make it real. Example one, a student with dyslexia who struggles to decode words, is falling behind in reading. They would qualify under specific learning disability because they need specialized reading instruction. Example two, a child with ADHD who can't sustain attention without support, causing them to miss large chunks of instruction. They would qualify under other health impairment, probably. Example three, a child with autism who has strong academic skills but significant social communication challenges. They might qualify under autism or speech and language impairment, and they might just need social skills training and social skills goals as well as speech services. We might not have any academic goals on their IEP. The main thing to remember is eligibility isn't about just having a disability. It's about how the disability affects learning and whether the child needs specialized instruction. If you believe your child may qualify, you can request an evaluation in writing and the school must respond. As I mentioned briefly on the last slide, there's 13 disability categories under IDEA, specifically under section 300.8, that can make a child eligible for an IEP. These are autism, blindness, deafness, emotional disturbance, hearing impairment, intellectual disability, multiple disabilities, orthopedic impairment, other health impairment, specific learning disability, speech or language impairment, traumatic brain injury, and visual impairment, including blindness. And the optional state category of developmental delay for children ages 3 to 9 if the state uses that category. So officially, IDEA lists 13 core categories with a potential 14th of developmental delay at the state's discretion. Each state may use slightly different definitions, but the federal law sets the framework. Above, you will see the statistics for which category all children with IEPs qualified under in 2023, according to the U.S. Department of Education, which I found very interesting. That being said, I have many families that come to me with a child who's been diagnosed with, let's say, level 3 autism for years, but the school qualified them under speech impairment, not autism. And so there's no record of the autism, and these numbers might not accurately reflect what disabilities the learners actually have, but instead what is reported on their IEP. Parents often ask me what the difference between an IEP and a 504 plan is. This is a really important distinction because while both provide support, they do very different things. Let's start with an IEP. An IEP is for students who qualify under IDEA, the federal special education law we talked about. Remember, they must have one of the 13 disability categories and need specially designed instruction. It's instruction focused. That means it changes how a child is taught. For example, a child with dyslexia might get a structured reading program taught by a special education teacher. An IEP is also a comprehensive legal document. It spells out present levels, measurable goals, services, accommodation, and progress monitoring. Think of it as the blueprint for teaching and learning that's legally enforceable. A 504 plan comes from Section 504 of the Rehabilitation Act. A 504 plan is a civil rights plan. It comes from an entirely different law than our IEPs. Again, this is Section 504 of the Rehabilitation Act of 1973, not IDEA. It covers students with a disability that substantially limits one or more major life activities. So it's a much broader definition than IDEA. A 504 plan provides accommodations and supports, but not specialized instruction or services. They help students access the general education curriculum on equal footing. For example, a child with ADHD who doesn't need specialized instruction might get extra time on tests, breaks during the day, access to sensory items, or preferential seating under 504. So let's go over how they differ and key distinctions. First of all, eligibility, an IEP, specific IDEA disability in one of the 13 categories, plus need for special education. Be eligible for a 504, any disability that substantially limits learning or another major life activity. Services, IEP, you get specialized instruction plus related services like speech, OT, PT, and counseling. And for a 504, accommodations are supports only. Accommodations and supports only. The process for an IEP requires a full evaluation, requires annual reviews, and a triennial reevaluation. A 504 process typically requires documentation of the disability, and it's reviewed periodically. For legal protections, both are legally binding and protected against discrimination, but IEPs are much more detailed and enforceable in terms of instruction, and therefore IEPs provide much more legal protections. Let's go over a few examples to clarify. So example number 1 is a student with autism who needs social communication goals, speech therapy, and behavior supports. Get in an IEP. Example number 2, a student with diabetes who needs to check their blood sugar and take breaks for snacks, but doesn't need instruction changes. 504 plan. Example number 3, a student with ADHD who struggles with organization and needs extra time, but does not need specialized instruction. 504 plan. For the record, I just want to say that not all students with ADHD are automatically 504 plan. We have a lot of ADHD students under other health impairment on IEPs. Just in this specific case, the learner did not need specialized instruction, therefore 504 plan. Example 4, a student with dyslexia who is 2 grade levels behind in reading and needs targeted reading instruction, IEP. Both IEPs and 504s are designed to level the playing field, but IEPs change how a child is taught. 504s change how a child accesses the normal curriculum. Knowing the differences helps you request the right kind of support for your child. I want you to be aware, though, because schools often try to take kids off an IEP and put them on a 504, or put them on a 504 to begin with when they should be on an IEP. This is generally, if I were to guess, because it requires a lot less from the school and you have a lot less legal recourse if something goes wrong. It might genuinely be because they believe they belong on a 504 plan, but they don't. So really look at, do they need specialized instruction and everything else we discussed today, and really do a deep dive on if they qualify for an IEP before going with a 504. And if you feel like you qualify for an IEP and the school is still pushing a 504, I suggest getting an advocate or an attorney involved. Now that we know what an IEP is and what it must include as well, let's talk about what kind of plan, and we know what kind of plan your child might qualify for. Let's talk about the people who make it work. So these are going to be the key players on the IEP team. When you walk into an IEP meeting, you'll see a lot of faces around the table. It can feel overwhelming at first, but every person is there for a reason, and each has a specific role. So let's break down who the key players are in the IEP process. First, and most importantly, we have parents and guardians, and if they choose, they're advocates or attorneys. Parents are the most important members of an IEP team. Don't let anybody make you question that. You know your child best. You know their strengths, their challenges, and what works at home. You are an equal decision maker, not just a guest. Schools cannot finalize an IEP in a lot of cases without your participation. Parents may also choose to bring an advocate or a support person or an attorney. Advocates help ensure parents' concerns are heard. They can clarify your rights and support collaboration. You can also invite others, such as private therapists. With almost all the learners we work with, we try to get private therapists at the IEP meetings whenever possible. You can invite tutors. You can even invite a trusted family member to provide insight or support. In meetings, I often hear statements in response to a parent or advocate's request like, "That's a team decision," or "We'll talk to the team and get back to you." And I often have to remind the school that the parents and advocate are on the team. There's no separate team. Teachers are at the IEP table. We generally have a general education teacher and a special education teacher. The special education teacher is the instructional expert for students with disabilities. They design and deliver specialized instruction. They can help write measurable goals and make sure accommodations are used consistently. The gen ed teacher can give great guidance and insight on what the child will need to succeed in a gen ed setting or what grade level curriculum is. A pro tip here is schools often try to excuse gen ed teachers from attending, or when you show up to the IEP meeting, that is when they tell you they're not available and they ask you to waive that right. I would be very wary of this if you want inclusion. If our child has any form of inclusion or that's something we want to talk about working towards, I would say you want a gen ed teacher at the table. Say that again. So with school, sorry, I just saw that chat pop up. Most of the questions, by the way, I've seen them pop up. We're going to get to the questions at the end. But for what I just said is schools often try to excuse gen ed teachers. They'll either tell you in writing, the gen ed teacher is not available. Do you still want to go forward? You sign this form excusing them from the meeting. Or when you get there, they'll just let you know the gen ed teacher isn't available. Is that okay? And they're asking if you still want to proceed. A lot of parents say yes, because you already took the day off. You've been waiting for this, for weeks, and you just want this meeting done. But if you do want inclusion, or your child has a need of inclusion, or you want them working towards inclusion, I would be wary of signing this. What we always do for our learners that we're representing, so that this doesn't happen, is we make it very clear in our email communications with the school beforehand that we would like the gen ed teacher to be present and we will not be waiving. So schedule it at a time they are available. If we have a child in self-contained, we know inclusion is not appropriate in any manner. The parents do not want inclusion. Sure, fine, excuse the gen ed teacher if needed. But if inclusion is a goal or something that's already happening, I feel they should be there. School administrator, or the LEA representative. This is often the principal, assistant principal, special education coordinator, or LTSE. That stands for lead teacher special education. Sometimes they're called different things in different areas. Many times, more than one of these people will come to the meeting, especially if you bring an advocate or attorney. When I show up, I generally get them all, which is great. More the merrier. They have an opportunity to contribute their opinions, but more importantly, these are the people with the authority to commit school resources. So if you have an IEP going forward and one of these people, again, I'll say it, principal, assistant principal, special education coordinator, LTSE, isn't even present, it's just like your SPED teacher or the gen ed teacher, it's going to be a waste of your time because they do not have the authority to approve any big changes, any additional services, staff, or support. You want somebody with authority in the room so decisions can actually be made and you don't need to reconvene. Sometimes maybe a lawyer for the school district will show up, especially if you bring an advocate or an attorney. They will almost always come. A lot of parents can panic. It is scary, I know, but I always tell my families in 95% of the cases, it's a great thing. Every now and then I get an attorney who, I would have done better maybe without them there. But they ensure that the school follows the law in most cases. It is important to note that they represent the school. They do not represent you, but they do not want their client breaking the law. A lot of times teachers and staff might think they understand what the law is and what they're doing is in good faith, but they don't really understand the principles of least restrictive environment. And so when a lawyer is in that room and they're saying something they shouldn't be, the lawyer is going to redirect the conversation back to where it needs to be. Or if a teacher says, well, yes, the student needs this, but we don't have the budget or we don't have the staff. Alarm bells are going to be going off in that lawyer's head because they know that that's against the law. And they're going to say, well, if they need it, we need to give it to them. So in a lot of cases, it can benefit you, even though they do not represent you, they represent the other side. So if you bring an advocate or an attorney, they'll almost always show up, but that's not necessarily something to be afraid of. A school psychologist or evaluator will often be present. They interpret testing and evaluation results, academic, behavioral, cognitive, or functional. They will be interpreting those results of the school evaluations as well as your private evaluations. Related service providers. These are professionals who provide specialized services written into the IEP. So a lot of times we'll have the SLP there, the occupational therapist, the physical therapist, behavioral specialist, counselor, or social worker, nurse, or other medical staff. They will be on the IEP team as needed. They might not attend every meeting, but they're vital when their services are part of the plan. So for example, special education nurses are sometimes there when we have kiddos with feeding tubes or severe epilepsy or some other severe medical issue that really needs a lot of their support and staff is going to need training on. Student when appropriate. As a child gets older, especially in middle school or high school, they might be invited to participate in their IEP as, you know, their parents. If you think it's appropriate for them, I always suggest you invite them. Even some of our younger learners, if they're verbal, they don't have to stay for the whole thing. They don't have to stay for the parts that are, you know, negative. We don't necessarily want them hearing that, but they should come. And if there's something that is important to them, they should speak about it. And it reminds everybody at the IEP table, this is a real person. This is a child. This is why we're doing what we're doing. And I think it's always helpful to have them there for a part of the meeting if, you know, they're verbal and want to be involved, even if they're not verbal, just to come and show their face as they get older. And then, of course, leave if we're having some of those tougher conversations and they're younger. We don't want them necessarily hearing that. By age 16, sometimes earlier, depending on the state, the student must be included in transition planning. So having the student's voice at the table ensures the plan reflects their goals and aspirations as well. Other team members you might see are a case manager. A lot of times our case manager is our special education teacher, but not always. They coordinate the IEP. A translator or interpreter if needed, they need to provide one. Specialists like vision or hearing teachers or representatives from outside agencies, especially in, again, transition age students, 16, 15. We're going to see sometimes people from job training programs or other agencies who might be invited to these IEPs. The IEP team is a partnership. Each member contributes a unique perspective, but parents and their advocates are the constant voice across all years and schools. So it's okay to ask, can you explain your role? How do you support my child? You should feel empowered to know who's at the table and ask any questions you have. Know that when we know who's at the table, now that we know who is at the table, let's talk about the different types of IEP meetings and what actually happens during the meeting process. So first of all, there are different types of IEP meetings. Not all IEP meetings are the same. When we're reviewing these different types, I find that knowing the difference between all of these and knowing exactly what type of meeting you're going into helps us know what to expect and how to prepare. The first type I want to talk about are initial eligibility meetings. This is when you are first trying to get your student an IEP or 504. You have gone through all the assessments. You're going to have an initial eligibility meeting to determine if they are eligible for services. It's the very first thing that happens after your child is evaluated. It happens once the school completes all evaluations and all the paperwork. And then in this meeting, they're going to talk to you about whether your child qualifies for special education. The team will review all the evaluation data. They will discuss whether the child meets the IDEA eligibility we talked about early on. And if so, they will create their first IEP. Sometimes, depending on your state and your district, this is all one meeting. The eligibility meeting, once they tell you you're eligible, you go straight into your first IEP meeting. And sometimes they have an eligibility meeting and then they schedule your first IEP. It's generally better when they do it together, but know when you're going to the eligibility meeting, it might go straight into your first IEP meeting. So if a child has just finished a reading evaluation for suspected dyslexia, the team will meet to go over the results. They'll decide the child qualifies for services under the specific learning disability category maybe, and then they might jump right into creating that IEP to help. Number two, our most common is the annual review. Every IEP must be reviewed at least once a year. This is called your annual review, or the school might call it just the annual. The team looks at the child's progress, updates the present levels, adjusts goals, and decides whether services and accommodations are still appropriate. They're also going to a lot of times discuss placement for the following year if you're having this towards the end of the year. Parents should come prepared with observations from home and concerns about the current plan. So an example is last year's IEP goal was reading 70 words per minute. At the annual review, the team checks the data to see if the goal was met and should be setting new goals for upcoming years. We do hear from a lot of parents who they're like, oh, goals were met. Maybe they don't need these services anymore. No, until they are at grade level, we need to be making new goals as they reach goals. Goals being met doesn't automatically mean we should drop services. Reevaluation meetings. By law, every child must be reevaluated at least once every 3 years. A reevaluation meeting can happen at the same time as your annual meeting. If a parent and the school, if the parents and the school agree a reevaluation isn't needed, that's something that can be discussed. Reevaluations check whether the child still qualifies for special education and whether their needs have changed. Parents can request a reevaluation sooner than those 3 years if they feel the current plan isn't addressing their child's needs. So an example is a student with ADHD is approaching middle school. A reevaluation might look at executive functioning and organizational skills to ensure the IEP reflects new academic demands that come with middle school. Amendment, revision, and review meetings. So I say this all the time on Facebook or anywhere you hear me talk. You do not have to wait for the school to contact you about your annual. You can call an IEP meeting at any time. If something's not going right, call a meeting. This will generally be an amendment or revision meeting. Or if you just need updates because you're not getting communication from the school, call a meeting. This could be a review meeting. Sometimes you don't have to wait for that annual review, and an IEP can be changed at any time throughout the year. So you don't, if they might say, oh, we just changed it or it's too soon, you can push back on that. If you need a change, you can ask for an amendment meeting and discuss it as a team. These are usually shorter meetings. They might be focused on one issue or a few issues, like adding the service or a problem that just came up, or adjusting minutes or clarifying a goal. Parents can request these meetings. The school can request these meetings anytime they feel changes are needed. Example, a student has recently started speech therapy outside of school. The parents might want to request an amendment meeting to coordinate services and add progress monitoring to the IEP. Or your child is suddenly having school refusal. You might need to call an amendment meeting to address this new issue. Transition planning meetings. We talked about this a little bit, but they need to be starting no later than age 16, though many states begin them earlier. The IEP must include a transition plan no later than age 16. Transition meetings focus on preparing the student for life after high school. That could include further education, employment, independent living. It could include staying in school till 21. Each student has a different path, but they need to evaluate that for the individual student. The student is a central part of these meetings whenever possible. Outside agencies like vocational rehab may also be invited. So an example is at age 15, the student shares they want to attend culinary school. The IEP team should include goals for career exploration and cooking-related vocational skills. It is really about helping the student achieve what their goals are, if they can tell us, and if that is something that they cannot express, it's about working with the family to determine what the family's goals are and what the next steps will be for that student. Other meetings you might encounter are discipline-related. So we have our manifestation determination reviews, or MDRs. They're held if a child with an IEP is facing suspension or expulsion for more than 10 days. The team decides whether the behavior was caused by or had a direct relationship to the disability. This leads to functional behavior assessments and behavior intervention plans. That's a whole nother topic, but just now know they exist. So a discipline-related meeting, such as an MDR, might be a meeting that you would be attending, or resolution or mediation meetings. These are less common, but they happen when parents in the schools have a formal dispute. They focus on resolving disagreements about the IEP. So IEP meetings are not one size fits all. They come in all different levels. Some are big and comprehensive, like initial or annual meetings. Others are focused and targeted, like amendments. I talk to families all the time who only ever go to the annuals and they had no idea that they could call meetings. But you can whenever you need to. Parents have the right to request a meeting at any time. You don't have to wait until the school calls one. You should always know what type of meeting you are walking into, though, and prepare accordingly. So let's look at what actually happens in an IEP meeting. Now that you've covered who is involved and the types of IEP meetings, let's walk through what happens during one of these meetings. Again, there are different types of IEP meetings, so specifically what will happen will depend on the type of meeting you're attending, but most IEP meetings follow a fairly standard flow. We have welcome and introductions. The meeting usually starts with a brief welcome from the IEP team chair, coordinator. Even if you met them before, we go around the table, we say everybody who's there. A lot of times, if you have an advocate or attorney, this is where they will tell the team that they plan on recording the meeting, or the school might tell the advocate or attorney that they are recording the meeting. We always record, and they always record, generally in all the meetings I've been to. Review of current performance will be next. The team will review your child's present levels of academic achievement and functional performance. These are also called the PLAFs. It's where everyone shares their observations, test results, progress reports, feedback. This section sets the foundation for everything else in the IEP. It is the most important section. We will talk about that a little bit later, but I do find this is the section parents often get the most upset about because it can be viewed negatively, but we will later discuss why these negatives are important and they're actually positive for you. Then they'll go into discussion of needs based on current performance, based on your PLAFs. They will identify the areas where your child requires support. This can include academic, behavioral, social, physical needs. I cannot tell you how many IEP meetings I'm in where the school tries to tell me that social skills are not a goal. Yes, they are under federal law. They need to help any area that is affecting the child's access to education, which includes accessing his peers or recess or PE. It is all included. We just need to make that educational argument on how it ties in. So this is where your insights as a parent or an advocate are crucial. You need to share examples from home or therapy or other environments where you see your child struggling with whatever it is you think they need to be focused on, because the school will often see different things than you do or see less. Goal setting and services will be discussed next. Once needs are identified, the team will develop measurable goals. They should be SMART goals. We'll talk about this soon. These will be for the coming year if you're at an annual, and they'll determine what services, accommodations, and modifications will support those goals. So for example, if you think your child needs more OT time, but you don't have goals that need to be supported by OT, you're not getting more OT time. So we need to make sure that when we have a child who needs OT, that we have goals addressing that. So if your child needs OT for fine motor skills and gross motor skills, do we have goals on writing their name or cutting or whatever it is they need help with? If they have issues with sensory regulation, do we have a sensory diet in there? Do we have a goal on self-regulation, fading towards independence? Do we have goals that the OT team can come in and support? Next would be progress monitoring and reporting. The team will discuss how your child's progress will be tracked and how you will receive updates. This ensures accountability and allows you to follow along throughout the year rather than waiting until your next meeting. And then you guys will do a final review and agreement. Before concluding, the team reviews all decisions, ensures everybody's on the same track, documents everything. That being said, a lot of times when we are in meetings, the draft IEP we get at a later date is not what we discussed on. So don't lock it in right away. Review everything and make sure it is what you believe was discussed. When I record meetings, a lot of times I can say, if you refer to minute 50 and 46 seconds on your recording, you will find that this was said and it's not included, or that additional services were added, but I do not see them in the report. That's why we always have recordings, because it backs up everything that happened. So tips for parents: take notes throughout the meeting. You're welcome to record too. We suggest you always let them know you are recording. I always let them know. Depending on your state, you might have to let them know. We just think it's better to do it from the start. Speak up. Your input is not just welcome, it's essential. If you disagree with something, don't feel pressured to agree immediately. You can request to take a pause, you can take notes, you can follow up after the meeting, and you can stand firmly in your disagreement. Make them give you a PWN. If they are not giving you what you want, you can do it respectfully, but make them give you that PWN, because that triggers, your next move. You can file for due process if you don't agree. You can file a state complaint, but we need it documented. PWN is what we discussed a little bit earlier, prior written notice. If you are coming in a little bit late, when you get the recording, you'll see a section on that. But a PWN is a prior written notice. It is a very formal document that anytime they are rejecting giving you something you need or are proposing to change, they need to be issuing PWNs. Keep the focus on your child's needs and outcomes. Concrete examples make your point stronger and clearer. Remember, the IEP meeting is a collaborative process, not a confrontation. Everyone should be working towards the same goal, helping your child access learning in the way that works best for them. So now let's take a deep dive into the components of an IEP. Each section has a specific purpose, and understanding them will help you know exactly what to look for and how to advocate for your child. An IEP will contain present levels of academic and functional performance, which is data-based snapshot of strengths and weaknesses, measurable annual goals. These are clear skills the child should learn and how progress will be measured. They should be SMART. We'll talk about that a little bit later. Specifically designed instruction, what instruction will look like and where it will happen. Related services will be in here. If your child is getting speech, OT, PT, counseling, assistive technology, transportation, that will all be in your IEP. Accommodations and modifications, as well as supplementary aids and services. So these are supports like visual schedules, extended time, reduced distractions, preferential seating. Participation in general and education state district assessments. There will be a lot in your IEP about testing, especially as our learners get a little bit older. Service details, minutes, frequency, location, start and end dates. If it's not written, it's hard to enforce. We want every single thing we agree to in our IEP. We don't want to make verbal agreements. I don't love written agreements outside of the IEP because the IEP is our legal contract with the school, but especially not verbal agreements. Whenever we do make a verbal agreement, follow it up in writing and CC your whole IEP team. And whenever possible, at a later date, get that added into your IEP. Placement will be on here. This will include the extent of participation with non-disabled peers or your least restrictive environment we talked about earlier. Progress reporting, how often are you going to get progress updates? What data will be shared? If you have behavioral issues or health issues, a lot of times here we're going to have our FBA or we're going to have an FBA, which leads to your behavior intervention plan, and your behavior intervention plan and the results of your FBA should be included in your IEP. Extended school year decisions. This will especially come into place in the summer, but know that ESY is not just in the summer, it's for any large breaks from school. A lot of times when we get ESY, it is in the summer, but the law says it's for, any breaks. We should be looking at this, or you can talk about it. Transition plans beginning no later than age 16, earlier in some states. So when we break some of these down, let's start with the PLAFs. This is the starting point of an IEP. It describes your child's current abilities, strengths, and area of need. It includes academic skills, behavior, social skills, communication, motor skills, anything else that affects learning. It answers the question, where is my child right now? So a lot of times we will have schools who put only positive things in because they know negative things will upset families, or families get very upset because this area can seem negative. But we want all of the negative in here as well, because this is what is supposed to drive our goals and our services and our accommodation. So if your PLAF doesn't accurately state what your child's struggling with, if it's all oh, they're great at colors. You want to make sure that that gets edited so it has all their strengths as well as all their weaknesses. And that way we can design our goals and our services on the weaknesses to follow. And if we need more speech and more OT, we have it in our IEP documented that this is something your child struggles with. Another tip is to bring examples from home, therapy, bring private evaluations, ensure that the plaque reflects these, and paint a full picture of your child. Any outside evaluations can be put into this section. We're going to look at that in a minute in our real world example. Do not let the school only focus on positives. We just talked about that. And remember that this is just one of the most important sections of the IEP. So if it's not accurate, everything that follows will be affected. Measurable annual goals. These are specific objectives your child should achieve over the next year if it's your annual. Goals should be SMART, specific, measurable, achievable, relevant, and time-bound. So again, specific, measurable, achievable, relevant, and time-bound. They should also be individualized and tied directly to your child's PLAF section. And they should be focused on areas that impact their access to education. Goals can be academic, functional, behavioral, social, or related to therapy needs. Special education and related services will be in here. This section lists the services your child will receive to help achieve their goals. Examples include specialized instruction, speech therapy, OT, PT, counseling, or assistive technology. This section will specify how often, how long, and in what setting these services will be provided. For example, will speech therapy be group or individual? Will it be a pull-out or a push-in? Pull-out is when your child leaves the classroom they are normally in to go to the speech therapy room. Push-in is when the speech therapist comes to them and performs speech therapy in their classroom. Tip, make sure the frequency and duration are sufficient to support progress towards the goals. So if they're only giving you speech therapy twice a week, but they have 13 speech therapy goals, ask them, how are you planning on achieving that in 60 minutes a week? State that you have concerns and your child should be in speech therapy more and propose your recommendation. Accommodations and modifications will be here. Accommodations adjust how your child learns without changing the content. Examples are extended time on tests, preferential seating, and a quiet space for work. Modifications change what your child is expected to learn. An example is reducing the number of problems on an assignment or simplifying language in a reading passage. Accommodations and modifications should be listed clearly so the teacher knows exactly what is expected. Placement will be on your IEP. It will describe where your child will receive their education. Is this in a general education room, a co-taught class, a resource room, self-contained, any combination of the above? It is determined after all the other sections are complete. The placement is based on your child's needs, not the other way around. Placement decisions should be flexible and revisited at least annually. It should maximize inclusion while ensuring your child gets the supports they need. Participation with non-disabled peers goes with that, and it will be on here. Remember, IDEA requires the school to educate children in the least restrictive learning environment. We just did a talk about this, I believe it was last month. This section explains how much time your child should spend with peers without disabilities, whether in general education classes, electives, lunch, or recess. Advocates often check this section super closely to ensure meaningful inclusion whenever possible. Just because your child is in a self-contained classroom doesn't mean they shouldn't be getting inclusion opportunities to the maximum extent possible, like the law says they need to. Number 7, progress monitoring and reporting. It will explain how the school will track your child's progress on goals. Make sure you understand how often you're going to be getting these updates and in what format. Every part of the IEP works together like pieces of a puzzle. The PLAF identifies the needs, the goals set the path, the services and accommodations provide the supports, placement ensures access, and progress monitoring tells us if it's working and provides us accountability. Understanding each section gives you the tools you need to make sure your child's IEP truly meets their unique needs. Just before we get into questions, I want to mention real quickly, If you do choose to hire an advocate to help you, we would love to assist you. We have multiple packages available for education advocacy, and we are one of the few advocates that offer flat rate packages instead of hourly rates, so you're not charged for every phone call or email, and you know exactly what you're paying up front, and we offer payment plans as well. Our packages include IEP and 504 plan reviews, IEP or 504 plan meeting support, or finally, our most popular package and most unique package is our annual advocacy package, which offers a full year of unlimited special education advocacy support. So you'll have an experienced advocate, me, by your side to guide you through every stage, ensuring your child's plan stays appropriate, responsive, aligned, and evolving. And all of that is for one flat rate price. We help you with all email communications for the school and any IEP meetings that come up during that year. We also offer assistance with funding applications such as Katie Beckett, Now Comp Waiver, HIP, Family Support Services, and Champions for Children. So after today's webinar, you'll just get an email from us with our full pricing and service list in case you ever need our services either now or down the road. And you'll also get a special discount for attending today. And if you're interested in any of our services, we always offer free consultations to discuss your needs. With that being said, let's get into questions. I saw them flying in the chats. You guys are also welcome to come off mute if you want to ask a question. And then if nobody has questions to ask, I will go into the questions that were submitted.